Hello and welcome to another of our short teaching videos. My name is George Dunn and I'm the Chief Executive of the Tenant Farmers Association. This teaching is part of a series under which we seek to shine a light on topical issues faced by the tenanted sector of agriculture. It's part of the TFA's growing YouTube library, which also features our webinars and many important industry updates. So don't forget to let us know your thoughts in the comments section below. And if you found this video useful, why not subscribe to our channel and you won't miss out on any of our new content as we produce it. And today we're going to hear from Caroline Squire, who's one of our expert rural surveyors here at the TFA. And she will be talking through what you need to know about the issue of forfeiture. However, before we get going, I'd just like to say that we're delighted that Roy Thorne's solicitors are sponsoring our 2025 virtual teaching sessions. For those of you who don't know Roy Thorne's is a national law firm steeped in agriculture. They have over 90 years experience advising landowners and tenant farmers alike. Their lawyers are active in farm tenancy policy groups, and they certainly do get the bigger picture. So whether it's about succession, or whether it's about a new farm business tenancy, or a dispute with the landlord, or a share farming agreement, or even a collaborative natural capital agreement, Roy Thorne's are there to advise and assist. So, moving on to today's topic, and our teaching is on forfeiture. This is being recorded at the beginning of 2025, so everything we cover today is correct at the time of that recording. So for advice on your individual circumstances, we do recommend that you call the TFA head office and ask to speak to one of our team of advisors. So without further ado, I'd like to introduce you to Caroline Squire. As I said, is one of our specialist rural surveyors here at the TFA, and she's going to talk you through the issues of forfeiture. So welcome, Caroline. The floor is yours.
Thank you, George. So firstly, forfeiture. What is forfeiture? Forfeiture of a lease is a legal right that allows a landlord to regain possession of a property from a tenant who has breached the terms of the lease. And a landlord can seek forfeiture where there is a clause within the lease which gives the landlord the right to forfeit the lease if there is a breach. Clauses allowing forfeiture can be found in both Agricultural Holdings Act tenancies and farm business tenancies. However, forfeiture is generally used more in FBT lettings, and that's because unless there is a break clause, the landlord wouldn't otherwise be able to regain possession of a holding from a tenant in breach until the end of the fixed term. Forfeiture is used less in AHA tenancies because the incontestable notices to quit, cases A to G, provide more certainty to regain possession than the forfeiture process. A landlord can waive their right to forfeit if they know of a breach and then subsequently do any act which recognises the continued existence of that lease, as the landlord will be taken as having accepted the continuance of the lease and waived his right to forfeit for that breach. So an example of this could be the landlord demanding or accepting rent, serving a rent review notice, or granting consent to diversify or sublet, whilst knowing that there is a breach of the tenancy terms. A waiver will only operate in respect of the particular breach, and the landlord will be able to forfeit for later breaches of the same covenant. So, for example, the landlord may waive the non-payment of rent for one quarter, but he may be able to forfeit in respect of the following quarter's rent if the tenant then fails to pay again and breaches that covenant again. Next slide, please. So the process of forfeiture, forfeiture can either be achieved by physical re-entry or by the service of court proceedings, and in practice, court proceedings is the most common method. Forfeiture for non-payment of rent in order to pursue that, the landlord must formally demand the rent first, unless the lease says otherwise. So, for example, the lease could say that the lease can be forfeited if rent is overdue by X number of days. And the lease could say the rent is due whether it's formally demanded or not, in which case a formal demand of the rent wouldn't be necessary. And for forfeiture for breaches of any other tenant covenant, the landlord must firstly serve what's called a Section 146 notice on the tenant in accordance with the Law of Property Act 1925. And the Section 146 notice must specify the breach, require the tenant to remedy the breach if it's capable of remedy, and require the tenant to pay monetary compensation for the breach. And after a reasonable period of time following service of the Section 146 notice, the landlord can then proceed to forfeit the lease. And what is a reasonable period of time will depend on the nature of the breach. If the breach is irremediable, time should still be given to the tenant to allow them to consider their position. So, for example, whether they should admit the breach, offer compensation, or apply for relief from forfeiture. Forfeiture terminates the lease, and it either takes effect on re-entry or when a possession order is issued by the court, and that will date back to the date of the service of proceedings. The tenant can, however, apply to the court for relief from forfeiture. In relation to non-payment of rent, the court may grant relief when it's considered just and equitable to do so, having regard to the proceedings, the conduct of the parties, and all other relevant factors. If the tenant pays all the rent which is owed, along with all costs to date, it's likely that relief from forfeiture may be granted. And for all other breaches, if the tenant remedies the breaches capable of remedy, pays reasonable compensation for those which aren't remediable, and if they undertake to observe the breached covenants in future, relief may be granted. The court also take into account the seriousness of the breach, whether it was willful, the personal circumstances of the parties, and whether the breach has occurred without the tenant's knowledge or consent when they make their decision. If the tenant does obtain relief, it's as if the forfeiture has never happened and all the lease covenants are enforceable for the entire period. In respect of costs, whether relief is granted or the lease is forfeited, the court have discretion over whether costs are payable by one party to another, and the court will generally only allow costs reasonably incurred to be payable by the other party. So therefore, if there were indeed breaches, it's likely that the landlord's reasonable costs may well be awarded to the tenant to pay, regardless of whether relief is granted or not.
Caroline, thanks for that. Clearly a very complicated area of law, but obviously now that we've got more than half the area of the tenanted land in the country under FBTs, forfeiture may become a more important aspect of the work going forward, and obviously a very worrying time for tenant farmers who might be involved in that as well. So just a few questions you won't be surprised to hear from your presentation. So what court can a landlord pursue forfeiture through?
So they can either pursue forfeiture through the county court or the High Court, but the county court would be the most common route in practice.
And why are court proceedings the most common method for forfeiture rather than re-entry?
So there's a number of reasons for that. Firstly, even after re-entry, the tenant can still apply for relief from forfeiture. And so there's no guarantee that prolonged court proceedings will be avoided by going down the re-entry route. And furthermore, forfeiture by re-entry means that the landlord will have to deal with the tenant's goods. So, for example, their livestock, and the landlord will have bailor's obligations towards them, i.e. they'll have to look after the livestock. And re-entry also needs to be peaceable. And where there's violence or a threat of violence, the landlord is susceptible to criminal prosecution. So particularly if there's someone on site who's opposed to the re-entry, there is a risk that the re-entry may not be peaceable.
Okay, and lastly, Caroline, what are some examples of breaches which are capable of being remedied and those breaches which are irremediable?
So examples of breaches capable of remedy would include non-payment of rent, failure to undertake repairs, and unauthorized use of the holding. And examples of irremediable breaches would include unauthorized assignment, unauthorized subletting, or parting with possession, because the tenant can't undo the fact that they have done any of those things. Or indeed, bankruptcy would be another example, which again can't be undone.
Caroline, that's great. Thanks very much for your time today. And for those of you who have got more questions around your individual position, you can get advice from the TFA by becoming a member. And currently, membership costs start from just £299 per year. So it is excellent value for money. And this will give you access to individual dedicated advice, information, and support from experts just like Caroline. For more information about the TFA and how we can support all farmers in England and Wales who don't own the land that they operate, just go to our website, which is www.tfa.org.uk, and there you'll find information about all of our upcoming events as well as news affecting your sector. So I really do hope that you found this teaching helpful. And if you're watching on YouTube, this teaching, as I've said, is part of our growing YouTube library, and you can get more information within that library. Let us know in the comments what you thought about this short video, and don't forget to like and subscribe to our channel so that you don't miss out on any new content as we produce it. So many thanks again to Roy Thorns, solicitors, who are sponsoring our virtual program of teachings and webinars. And thank you for joining us on this session.